So as the title already suggests, I will look at two measures, detention and restriction on freedom of movement, in the context of both the current legislative processes in Brussels at the EU level and in the context of the COVID pandemic. So my presentation will have a quite straightforward organization. First, I will look at detention. After this, I will move to the restriction on freedom of movement, and I will finish with a few concluding thoughts. The two main parts, meaning immigration detention and restriction of freedom of movement, will also have quite similar outlook. I will start each section by outlining the international legal framework governing or restricting this measure. And against this framework, I'm going to discuss the current legislative amendments or processes around the EU law basis for these measures. And I will finish each section with a few words about practices around these measures in the context of the COVID pandemic. Before I will start, let me just say a few words about what I call the current legislative processes. I'm sure this was already discussed in the previous sessions today. Unfortunately, I was not able to join. So let me just say a few words. First of all, I will look at the recast of the Return Directive, which regulates immigration detention or pre-removal detention. So the Commission proposed the recast of this directive in September 2018. The Council adopted its partial position in June 2019, and the European Parliament resumed its work on this file recently. And now in the pact, the Commission is calling upon both legislators to move on with this file. Another legislative proposal that I would be looking at is the recast of the Reception Conditions Directive, and the situation is as follows. So the Commission proposed the recast of this directive in July 2016. The Parliament and the Council reached a partial provisional agreement in June 2018. But after this, the Council has not given its final endorsement. So the process has been pending for a while, but probably it will also move on after now the publication of the pact, because the Commission also calls upon the co-legislators to move on with this file. So this was as the background, and now let me pass to the section on detention. So as I mentioned, I will first look at international legal framework governing immigration detention. Secondly, I will look at the detention provisions under the Return Directive, and particularly proposed recast of these provisions. Then we'll do the same with the Reception Conditions Directive, and I will finish with a few examples of detention-related measures adopted or not adopted in the context of the COVID pandemic. Immigration detention under international law. There is no widely or universally accepted definition of what constitutes an arbitrary immigration detention, but the authoritative bodies interpret the concept of the arbitrary immigration detention in a complementary manner. And here on this slide, you can see the statements of a few of these bodies, and let's go quickly through their interpretation. So first of all, for the European Court of Human Rights, and you can see on the top of the slide, in order not to amount to arbitrary detention, immigration detention should be carried out in good faith. It should be closely connected to the ground of detention relied on by the government. The place and the conditions should be appropriate, and the length of detention should be reasonable. Then, for the UN Human Rights Committee, immigration detention may be arbitrary under the International Covenant on Civil and Political Rights if it is not necessary in all the circumstances of the case and proportionate to the ends sought by the government. And finally, for the UN Working Group on Arbitrary Detention, arbitrary immigration detention comprises the cases when asylum seekers, immigrants, and refugees are subjected to prolonged, administrative custody without the possibility of administrative or judicial review or remedy. So seeing already this ways of interpretation of the concept of arbitrary immigration detention, we see some elements. So we see the grant, we see emphasis on the necessity and proportionality, we see the requirement of the length, the review of detention, and the conditions and regime of detention. And these elements are typically clustered. Yes, are typically clustered into under the three headings. So first of all, which altogether constitute what we call international human rights framework governing immigration detention. So first of all, there are requirements relating to the justification of detention, secondly, procedural safeguards, and lastly, conditions of detention. In terms of the justification of detention, what I mentioned already just before, it's about, first of all, the grants for detention. So detention should be based on the grants provided for in law, and the legal basis should be clear, precise, and foreseeable in its application. Secondly, necessity and proportionality means that lawfulness itself is not enough to prevent arbitrary detention. Immigration detention should be a measure of last resort, applied only when non-custodial measures would not be able to achieve the objective of detention in a given case. Then, regarding the length of detention, in line with the principles of necessity and proportionality and the administrative character of immigration detention, so detention of migrants should be as short as possible. And the two another sets of safeguards, procedural safeguards and conditions of detention, I will look much less at them during my presentation because they're not covered by the amendments to none of the two directives, but just a few words. Procedural safeguards, meaning detainees should have access to the review of the detention in order to ensure the detention is lawful, is necessary and proportionate, and the length is adequate. And finally, the conditions and the place of detention, like all other detainees, immigration detainees should be offered conditions which are adequate and are in line with the inherent dignity of every person. And then in addition, since they are administrative detainees, they should be offered conditions and regime which reflect administrative, meaning non-punitive character of the detention. As I said, the amendments to the detention provisions in both the directives address only justification of detention, and these are the elements that I will look at now. So, the Recast Returns Directive. So, in terms of lawfulness of detention, currently there are two grants allowing states to detain people in pre-removal procedures, which is the risk of absconding and facts of avoiding or hampering the return process. In its Recast proposal, the Commission, I would say, seeks to expand the legal basis for detention, and this is done via 3 amendments to the current rules. First of all, the Commission proposed a 3rd grant justifying immigration detention, and this would be a grant, let me just quote it correctly, yes, on account of public policy, public security, or national security. And these grants are typically quite broad and leave quite a wide discretion to authorities. In addition, they blur the line between what is really administrative detention and non-punitive measure and penal detention. Secondly, in terms of the risk of absconding, currently the criteria for establishing the risk of absconding are not laid down at the EU level. Member states providing for their own list of this criteria, and this of course has its own problematic sides. And probably to end this widespread domestic list, the Commission is proposing a list which comprises not less than 16 criteria and which are in addition not enumerated in an exhaustive manner. So it means that the countries can have additional grants. Obviously, this would expand the legal basis to detain. This would expand the justification and possibility to detain people in pre-removal procedures. And the third amendment would be an obligation for states to transpose all the grants from the directive to the domestic legislation. Secondly, in terms of the necessity and proportionality of detention, the amendments proposed risk leading to systematic detention. Why? In order for detention to comply with the requirements of necessity and proportionality, it should be adopted as we said, as a last resort. It should be really exceptional measure. And there are some reasons, grounds or justification for detention which can lead to quasi-automatic detention. And these are all the reasons that relate to the irregular stay itself, or to some kind of conditions that people in pre-removal procedures typically would fulfill. And in the Recast proposal, among the 16 criteria for establishing the risk of absconding, there are some of these problematic criteria. For instance, the criteria that the Commission proposes to insert are lack of identity documents, false identity documents, lack of address, irregular entry, and lack of financial resources. So I would say there is a risk that irregularity of someone's stay would imply detainability. And this goes, of course, against the principles of necessity and proportionality. And the final amendment to the detention-related provisions under the Recast Return Directive relates to the length. Currently, the maximum length of detention under the directive is 6 months, extendable to 18 months, and it has already discussed and criticized in the past. Both the period of detention and the grounds on which countries may extend detention up to this maximum period can hardly reflect administrative character of immigration detention. What the Commission is seeking to change is to prevent countries from having shorter detention than 3 months. I would say that currently few countries that have shorter, under law, of course, shorter detention than 3 months, but still there are. For instance, in Spain, detention is shorter. If I'm not mistaken, I think 2 months. No, sorry, 3 months. Or, sorry, 2 months. Or in Sweden, the initial detention is also 2 months. So it would so having the minimum period of 3 months would actually lead to automatic detention for at least 3 months. And again, it's a question of necessity and proportionality, which would be legitimately asked. And now maybe just a final word around this. Widening the legal basis for detention, of course, would lead to more people being detained. While actually there is no evidence about the correlation between number of detainees and number of returns. So there is still no evidence that really more detention leads to more return. Let me now pass to the to the Reception Conditions Directive. Here again, I would say we can observe an attempt to widen the legal basis to detain. And again, this raises the questions under the principles of lawfulness, necessity, and proportionality of detention. Currently, there are 6 grounds on which member states can detain asylum seekers during asylum processes. Let me read them. So this is to determine or verify identity or nationality, determine elements of asylum application which could not be obtained without detention, in particular when there is a risk of absconding. 3, to decide on the right to enter the territory in the context of the border procedure. 4, if the person in pre-removal procedures applies to asylum and the country can substantiate that this is done merely to delay or frustrate the return process. Then for national security and public order protection, and finally in the context of Dublin regulation. So in this recast proposal, the Commission is proposing an additional ground justifying detention of asylum seekers. This would be to ensure compliance with residence restrictions. I will look at residence restrictions in a bit, but just for now, to make it clear, under this grant for detention, someone could be detained to ensure compliance with these restrictions on the person's freedom of movement if the person has not complied with this obligation and the risk of absconding. So we see some kind of a continuum between restriction of freedom of movement, which is enforced with detention by applying detention rules, and also in a way justification for restriction of freedom of movement in a way becomes grant for detention. So we see some kind of blurring lines, what justifies what, and indeed in some kind of continuum between restrictive measures. And the second element of this grant is, of course, the risk of absconding. So currently, the risk of absconding is not defined, and the Commission, in its recast proposal, proposes a definition which is broad and which is problematic. It is an action by which an applicant, in order to avoid asylum procedures, either leave the territory when they are obliged to be present under the Dublin system, or do not remain available to the competent authorities or the court or the tribunal. So the definition is broad. It does not say what it means not to be available to the authorities. So there is a risk of wide interpretation of this notion. And in addition, we have the creeping in the Dublin rules, meaning if someone left the first country, typically first country of arrival under the Dublin rules, the person is almost a potential absconder in the country where he or she is applying for asylum. So as I said before, as regards to the Return Directive, here again is a question of a notion of lawfulness and necessity and proportionality, meaning detention should be applied as a measure of last resort. Now let me say a few words on detention practices in the context of the COVID. I would say that there are considerations relating to both lawfulness and necessity and proportionality that call against immigration detention in the current context. In terms of the lawfulness, and you can see it also on the slide, it's written lack of reasonable prospect of return. In the current context, return often is not possible for either legal or practical considerations, and many countries reduce the number of returns. And the EU and Strasbourg law, immigration detention is lawful, is permissible when there is a reasonable prospect of return. Once this prospect does not exist, immigration detention loses its legal basis. So it's a question of lawfulness. And secondly, public health, knowing risk of transmission of virus in closed and custodial settings, it's really questionable whether immigration detention is a measure of a last resort in line with the principles of necessity and proportionality. And based on these two considerations, we've seen various domestic practices. So first of all, we have not seen a clear policy. It was much more dealt on a case-by-case basis. Generally, in spring, so March, April, many countries, people have been released from immigration detention. And for instance, just to give an example of a few countries that have done so we can speak about Spain, France, Germany, Italy, Sweden, Denmark, and the UK. As I said, in most of these countries, this was done case by case, either by the court, like in France, or by the authorities, so meaning administrative authorities. This would be, for instance, Slovenia and Sweden. This depends, of course, which bodies are charged in supervising detention. There have been also various domestic judicial approaches. For instance, recently, the Dutch High Court said that even if there is no prospect of return, still that should be decided on case-by-case basis. It cannot be decided in a broader manner. In France, also the courts are releasing less people on detention, this time on public health considerations, because they are saying that since there are less people detained, so this distancing is possible. So the court's approach is also changing. Now the situation is changing again, and it's so difficult to pull some kind of general conclusions again, because it's often adopted on a case-by-case basis and changes between the countries and also even between detention centers. So in some countries, there are still less people detained. So for instance, would be Netherlands. In some countries, it's already increasing the number of detainees. So for instance, in France. And in other countries, there's definitely more people detained than in spring, for instance. So this would be Switzerland, Denmark, Spain, or Germany. There has been a negative side effect in that those people who are detained, they're often detained for longer than they would be in normal circumstances because of difficulties in returning. So we have bringing back the concept of the reasonable prospect of return, which again blocks the return procedure and actually extends detention. And this can be observed in some centers in Denmark and in France. I should move actually faster. So let me now move to the second part of my presentation, which is restrictions on freedom of movement. And again, I will first start briefly with outlining international human rights framework governing this measure, and then I will look at the recast proposal of the Reception Conditions Directive, and I will finally discuss a few measures adopted by states in the context of the COVID pandemic. Yes. So under international law, measures which do not amount to detention, but still restrict someone's freedom of movement, are also very tightly regulated. It's not only detention that should comply with the principles of lawfulness, necessity, proportionality, but measures that still restrict someone's freedom of movement are also tightly regulated. And the basis for this framework is found both in international human rights law and refugee law. And as you can see on the slide, under these provisions, everyone, or refugee in the context of refugee protection, who is lawfully within the territory of the state, has the right to liberty of movement and freedom to choose his residence within the territory. So, of course, first question that arises, what does it mean, the lawful presence? And according to the Human Rights Committee, the lawful presence is governed by domestic law, which can impose the conditions on the entry to its territory, but this condition should comply with the country's international obligations. Under EU law, under the Asylum Procedures Directive, asylum seekers within the procedures and at least at the first instance level do have right to remain on the state's territory, so are lawfully for the purpose of the freedom of movement. Beyond the refugee protection, the Human Rights Committee found in its case of Seleppi versus Sweden that even expulsion order cannot be enforced because of the risk of ill treatment. Upon return, the person's stay in the host country continues to be lawful. In the same way as detention, the right to freedom of movement is not absolute, and international law permits countries to restrict this measure, this right. And the restrictions, in order to be lawful under international law, should comply should be provided for in law, should serve one of the listed legitimate purposes, which I'm gonna look in a moment at, should be necessary for achieving these purposes, and should be non-discriminatory. The legitimate purposes, let me just read them, are the protection of national security, public safety, public order, health and morals, and the rights and freedoms of others, and prevention of crime. So with this in mind, let's have a very quick look at the restriction on freedom of movement under the current Reception Conditions Directive and the proposed recast. Yes. So currently the directive allows states to restrict the applicant's freedom of movement in two manners. For the sake of time, I'm gonna just look at one of them. So first one is assignation to a specific area. I'm not gonna look at it now. And the second is its decision on actual residence. And this is under the directive, states may do it for reasons of public interest and public order. So these reasons are legitimate under international law, but the measures should be necessary for achieving this objective. And there is other reasons under which state may assign applicant to a specific residence, which are not provided in international law. This is swift processing and effective monitoring of the person's asylum application. Reasons for administrative convenience do not belong to legitimate reasons on which member states can restrict someone's freedom of movement. So this is very problematic. And in addition, in the recast proposal, the Commission seeks to expand this possibility of restricting freedom of movement. And first of all, it turns currently a may provision into an obligatory one, so it will be a shall provision. However, it also introduces a proportionality test and individual assessment. So it will be interesting to see how these two notions play together. What is more problematic is that the Commission introduces an additional grounds on which member states can restrict the person's freedom of movement, meaning assigning the person to specific accommodation residence. And this is, again, for reasons of administrative convenience within the Dublin system. So this is, however, quickly, in order to swiftly process and effectively monitor the Dublin procedure. So again, these reasons are not provided for under international law, and they do not constitute a legitimate restrictions on someone's freedom of movement. And when this, if these amendments are adopted, it risks providing for really wide basis for restricting people's freedom of movement and creating a general surveillance system. A few words very briefly about restrictive measures adopted by states in the context of the COVID pandemic. So first of all, in detention, what we have observed, detainees have less freedom of movement inside detention centers. And this had been observed in the past in Denmark. Now it's less problematic in many centers. In Netherlands, it's still there. So there's less time they can spend outside of the room, and much less activities. And now in these places, the regime of immigration detention actually resembles the regime of prisons, actually, of penitentiary. Secondly, some states adopted measures which blur the lines between what is restriction of someone's freedom of movement and what is actually detention. And such measures have been observed in, for instance, Serbia and Greece. In Serbia, asylum seekers were prohibited from leaving reception centers. And in Greece, it was a similar measures on the islands when there was a partial prohibition on leaving the centers. Officially, it was to prevent the spread of the virus, but it was adapted in the moment when other restrictive measures applicable for the population at large were being lifted. So these were measures adopted on a discriminatory basis and were definitely not necessary and proportionate, because at that time there was no health policy reasons for doing it, since the rest of the population benefited from increasing freedom of movement. I know I'm running out of the time, so a few words of the conclusion. So first of all, under the recast of the Returns Directive, there is a risk of a strong widening of legal basis for detention, while there is no clear evidence that more detention translates into more returns. Secondly, under the recast of the Reception Conditions Directive, the Commission seeks to expand the legal basis for the restriction on freedom of movement, and there is a risk of creating a system of generalized surveillance of the population. Thirdly, in the context of the COVID pandemic, we've seen very divergent and different measures applying between the countries and within the countries. On one hand, many people have been released. On the other hand, those who have not been released are risking longer detention under the regime applicable to normal prisons. And we also observe freedom restricting measures which blur the lines between restricting freedom of movement and detention. Yes, I think I've covered all the 5 main points of my conclusions. I know I exceeded the time. My apologies for this, and I'm open for any questions and comments from your side. Thank you very much for your attention.